So welcome to the first day of the 7th edition of the Cambridge Arbitration Days. We have one panel today on sports arbitration, which will follow this brief welcoming remarks. And then tomorrow we'll have a full day of panels on investor-state arbitration, construction arbitration, and commercial arbitration. We cannot describe how excited we are to be here today in person in the faculty. This has been the first Cambridge Arbitration Days post-pandemic and the first in-person conference in the Faculty of Law of Cambridge since then. So we would like to we extend a warm welcome to all of you today. Over the past 2 years, I mean, of course, COVID is still a reality, and it has affected over the past 2 years our lives and work, and quite honestly, the organization of this conference, from both of us catching it last month to not knowing whether we would have a venue for the conference until late, to speakers dropping out at the last minute because of COVID. But the important thing is that we are here now, and we consciously decided this year to kind of defy this reality and to, on the one hand, not focus on let's say, pandemic-related topics. And of course, COVID has affected the international arbitration practice. And these issues has admittedly thoroughly and extensively discussed in virtual conferences throughout the past 2 years. But also, we consciously decided to hold this conference in person, and this was a primary concern and conscious decision on our part. And this is because while we admittedly have all enjoyed the occasional online seminar in our pajamas while eating McDonald's at home or at work without having to reschedule our whole day to attend an interesting seminar, both of us missed this aspect of an important aspect of professional and academic conferences and events, and this is the in-person interaction. We missed the ability to meet new people in the same room and make new friends, and discuss after an interesting presentation over drinks and canapes, which we hope we will be able to do over the next 2 days. So before I take my leave and give the floor to this incredible panel of sports experts, I wanted to say some thank yous that are very much due. And first, I would like to warmly thank our sponsors for the generous support. And I will take just a few seconds to tell the names of the organization and the firms, which are Candy, our gold sponsor, our silver sponsors, Clifford Sands, Arnold & Porter, Pinero Neto, the London Maritime Arbitrators Association, as well as Three Crowns, Zed, Altenburger, Ashurst, and DLA Piper. Without their contribution, this conference could not have been a reality, and definitely not free of charge for participants. I want to thank you, all our speakers, some of whom you'll meet today and some of whom you'll meet tomorrow, for making time in their admittedly very busy schedules to be with us today, to hear from them and discuss with us. I want to thank you, my co-convener, Mel Schwing, and the committee, the extremely hard-working organizing committee that made this conference possible with all the bumps that we faced in the road. And I wanted to thank the faculty for hosting once again this conference. And last but definitely not least, I want to thank all of you for making the time and honoring us with your presence today. And with that, you have anything to add?
I don't think they want to hear from me. I think they want to hear from these 5 members of the panel.
Amazing. Mel will be also moderating this panel, so you'll definitely hear from him. And with that, the floor is yours.
Welcome, everybody, to the first panel of the 7th Cambridge Arbitration Days. As Lena said, my name is Mel Schwing. We have an outstanding panel of sports arbitration experts for you today. I'm just going to briefly mention who they are, going from the farthest to the closest, and then I will introduce them in more detail one by one as they give their presentations. Down at the far end is John Mehrzad QC, a barrister from Littleton Chambers. He will be speaking on arbitrator impartiality and lists in sports arbitration. Next to him is Dr. Leanne O'Leary, a senior lecturer in law from Edgehill University. She will be speaking on switching teams mid-match should sports arbitration parties be allowed to change their factual position on appeal. Next is Paul Gilroy, QC, a barrister from Littleton Chambers. He'll be talking about the Russian anti-doping scandal and the recent CAS decision to reduce WADA sanctions. Was the CAS panel too lenient? Next, Udo Onwere from Bray Krais will be talking about giving insights into the Football Association arbitration panels. And finally, Jeff Benz, a door tenant at 4 New Square, arbitrator and mediator at JAMS, will be having reflections of a CAS arbitrator. Like I said, I know you don't come here to hear me talk, so let me get straight to it. Our first presenter is John Mehrzad. John practices in sports law and business protection law at Littleton Chambers in London. Amongst other appointments, he is an independent arbitrator in FA Rule K and English Football League arbitrations, an independent FA discipline chair, a legal aid panelist at the Court of Arbitration for Sport, CAS, and is on the panel of independent arbitrators for sports resolutions, or sport resolutions. His sports law practice focuses on the one hand on financial disputes in sport, and on the other, on regulatory issues, including disciplinaries, including doping offenses, selection, and safeguarding issues. John was appointed QC in 2000 after only 12 years in practice. Very impressive feat there. But like I said, you did not come here to hear me speak. You came here to hear people like John speak. So with that, I cede the mic to my friend John Mehrzad QC.
Thank you, Mel and Alina, for that very humbling introduction. Can I just say, as a graduate of the other place, I was glad that when I arrived here, you all kindly were in attendance, because I did wonder whether this was going to be an April Fool's joke, that you'd bring me up and there'd be absolutely nobody here, some sort of joke on an Oxford graduate. Now, what I want to do is first of all ask everybody in the room a question. How many of you have experience of participating in sports arbitrations? And that is why it's the first session on sports arbitrations. Well, that's very good, because what I'm going to do is I'm going to give you a whistle-stop tour of domestic sports arbitrations, meaning the FA, the Premier League, the English Football League. I will touch on the Court of Arbitration for Sport, but I have far superior fellow panellists, Leanne and Jeff, who are CAS arbitrators, so they will regale you in due course with stories of the reality of the CAS. And then I'm going to look at some very recent decisions domestically challenging lists in domestic sports arbitrations, and also the impartiality of a very grand and well-known arbitrator. So let me start off by giving you an overview about panel composition. Now, what you will find by way of a headline is that there is no one size that fits all, which you might find slightly curious, because, of course, the issues that these arbitration panels deal with are all often very, very similar. Most of the time, in terms of myself, as Mel said, we're talking about contractual disputes between players, clubs, managers, intermediaries, meaning their agents. And those are the core financial disputes. But the way these panels are composed are slightly different. So let's start off with FA Rule K arbitration. So generally, FA Rule K will apply when there isn't an express arbitration clause giving jurisdiction to the Premier League or the English Football League. And so you are talking about the majority of disputes. And what happens there is that the parties choose their own arbitrators, and they seek to agree a third arbitrator. There is no provision for any level of experience, but of course, ordinarily, the types of arbitrators who are appointed tend to be specialists, tend to be fairly well-known figures within the sports law world. Premier League is slightly different. Parties choose their own arbitrator and seek to agree a third arbitrator, all of whom must be a suitably qualified person. So there is a caveat to the Premier League, suitably qualified person, meaning somebody who has been in practice for 10 years and is fully independent and impartial, and that's written into the rules. So there's the additional caveat to the Premier League. English Football League, again, very similar. Parties choose their own arbitrator, same caveat, minimum 10 years experience, independent and impartial, and that the EFL asks the Chartered Institute of Arbitrators or another body to nominate the third arbitrator. So there are slight nuances there. It doesn't always go to plan. So what happens when a sole arbitrator or a third arbitrator cannot be agreed? I would say in my experience, probably around 50-50 that I have sole arbitrators compared to a full panel. Now, where an arbitrator cannot be agreed, then in terms of FA Rule K arbitration, the FA's nominee chooses who that arbitrator is to be. And the FA's nominee is the independent body Sports Resolutions. Now, I asked my fellow panellists, I think there are 4 of us who are on Sports Resolutions panel, so naturally we have a great affinity towards them and, great panel. But let me tell you a little bit more about the numbers on that panel, because I'm going to show you that this is where the ranges between the numbers on each panel between these different jurisdictions can vary quite dramatically, and that is where the challenges have arisen from. So Sports Resolutions, spoke to them earlier this week, they have around about 300 panellists on their general arbitrators lists. Those are QCs and barristers, solicitors, also specialists in certain given areas. So, for example, could be safeguarding, could be accountancy. They serve for a 3-year renewable term. Exceptionally, certain outstanding candidates can be appointed during that 3-year period. And those are typically senior judges who've retired. And if you look up recent Sports Resolution decisions and nominations to various panels, you will see the greater and good of previous Supreme Court members who are now often sitting on these kinds of panels. Now, the Premier League is slightly different. Now, the Premier League board appoints unless the Premier League is a party, in which case the FA appoints. So the FA then goes back to this nominee whose Sports Resolutions, I've explained that. The Premier League, though, is quite different. It has 3 different types of arbitrations. It has general arbitrations, and parties can choose their own arbitrator. They have a judicial panel, and they also have manager arbitration tribunals. The giveaway is in the name, what issue they deal with. Now, judicial panels and managers arbitration panels are chosen from a list. That list is currently 22. When you take away specialists, there are really only 12 members of that list. We will come back to the challenge of that appointments process in due course. EFL, its nominee is Sports Resolutions, so the same process that I discussed before. So in effect, other than the Premier League, all roads lead to Sports Resolutions unless there is agreement between the parties. I said I'd only briefly touch on the Court of Arbitration for Sport over in Lausanne in Switzerland. Parties appoint their own arbitrators from the CAS list. Now, the CAS list is somewhat controversial. I'm sure Jeff will debate me on this slightly later. It is called a closed list. There are, I've looked up the numbers just the other day, there are 379 general arbitrators on the CAS list. They have a 4-year renewable term. But the controversies about it is my final bullet point, that the majority of the arbitrators are nominated by governing bodies. So you're talking about international federations, the IOC, and national Olympic bodies. Hence the suggestion in the Mutu and Peckstein case. Adrian Mutu, former Chelsea footballer, spent about 10 years in litigation, and Claudia Peckstein, speed skater, again, many years in litigation, both before CAS, the Swiss Federal Tribunal, and German courts, suggesting that that closed list meant that there was not, in effect, a fair process, especially as Peckstein suggested that she had no choice but to agree to the CAS procedure. The European Court of Human Rights did not agree with that. There are other aspects of that decision which I'd encourage you to look at as well. Now, I'll simply sort of say this, that one of the controversies about the CAS is that, like other areas of international arbitrators, there are so-called super arbitrators, around about half a dozen, who tend to be appointed in the vast majority of cases, and certainly big cases involving football. And so the 379 figure, you'll find a majority of them have never actually sat on a case. But, you know, as I said, that was challenged in terms of Mutu and didn't get anywhere. Right, let's move on to domestic challenges. Now, there's one recurring theme that you might find in the two clubs that we are looking at now. One, they probably had, bottomless pockets of money. And secondly, they were prepared to spend it in order to challenge the Premier League in terms of decisions that had been made or they were trying to make. Newcastle United against the FA Premier League, Michael Beloff, Lord Neuberger and Lord Dyson. I did say the former members of the Supreme Court have now appeared on these panels. Amongst other matters, this was a direct challenge to Michael Beloff, who's generally viewed as the doyen of sports law, in terms of his impartiality. Now, the facts are that he provided a declaration to the parties saying that no circumstances existed that would give rise to any justifiable doubts about his impartiality. You will recognise that, of course, from the Arbitration Act, that being the test. What subsequently transpired is that he had, in fact, advised the Premier League on 4 occasions, including about the Premier League rules. He was being tasked with considering one aspect of the Premier League rules in this arbitration. And you will probably recall this was all about the takeover of Newcastle United, the kind of fit and proper test. Now, he hadn't advised on the specific rule, but he'd certainly advised on the handbook. What also happened is that Michael Beloff then communicated on a unilateral basis with Bird & Bird, the solicitors for the Premier League, inquiring about his previous advice and did not copy in the solicitors for Newcastle. This goes to the High Court. There is, at the very least, implicit criticism of his conduct. He should have disclosed his prior instructions, should not have communicated only with the Premier League. However, because his advice had been given more than 2 years previously, there was no continuing instruction, and his reputation in a niche area, citing the Halliburton case, which of course identifies specialist areas, he was not found to have lacked partiality, and there was no order for his removal. Of course, that is a nice legal point. You will recall very shortly afterwards, with a lot of money having been spent, Newcastle then achieved its takeover. Now, one can only but imagine what costs had been incurred up until this point. The next challenge, only a month later, Manchester City. Having previously thought they were the richest club, and then Newcastle came along, well, Manchester City still have a few quid. They challenged the panel, Michael Havers, Mackle QC, Daniel Alexander QC. And this is different. It's not about impartiality. It was the process of how the Premier League list was composed in the first place. And you can remember how I talked about the 379 arbitrators at the CAS, the 300 at sports resolutions, and then I said in real terms about 12 at the Premier League, certainly at this stage. A few more have gone on since then. And it was a direct challenge. And what was not in dispute is that there had been no written policy for appointments. There'd been no selection criteria. Quote unquote, it had been a word-of-mouth process. Now, I don't want to put my fellow panelists on the spot, but I certainly remember receiving the email from a well-known silk at the bar. And of course, one of the quid pro quos of appointments to the Premier League is then you cannot appear in front of the Premier League as counsel. So that further limits in real terms the number of people who might go onto it, because of course that would, stymie their practice to a certain extent. Now, Manchester City as challenge to this, you might think that that was, quite good grounds, but the problem was that the relatively informal process had been raised at a Premier League meeting. They were aware of it. They never challenged it, and in fact had approved it along with the rest of the Premier League. Maybe at the time in which this was set up, they didn't think that they would want to challenge it. And the decision here, again, was to find that the appointments process did not breach the principle of independence. And a very similar ratio here. There was a small pool of candidates, specialist knowledge required. All members of the then panel, I'm not sure if all of them, but certainly a lot of them, were senior commercial QCs. And then you always then fall back on that well-known approach in every single impartiality challenge, which is, but they are subject to their code of conduct and their ethics. And therefore, it almost goes without saying that they know the standard of ethics that they need to abide by. So Manchester City fail. But again, bigger picture. In 2019, the commission of the Premier League was first started. And this was into alleged football financial fair play breaches by Manchester City. In other words, did they balance the books by inflating certain forms of commercial sponsorship from related entities to their owners? There has still, as far as I'm aware, because this was unusual because it went to the courts, but as far as I'm aware, because this would be a private process, there has still not been a decision on this. And so, a process that starts in 2019, we're now 2022, there was an interesting dicta from the Court of Appeal about this. When they decided that this should be a matter which was published, they said it is of public interest to know that a club that is facing a football financial fair play charge has effectively been able to drag out the process for now almost 3 years. And in the meantime, and this was a little dig, I think, from the particular Lord Justice, they had won 2 or 3 Premier Leagues. So I want to finish off, I think I'm still just about on time, just with some comments about double hatting. I almost put down triple hatting at one point, but I'm not quite sure whether that is a formal term. FA Rule K. There's no express rule to say that counsel cannot also act as an arbitrator. But of course, you have to declare independence and impartiality, so you wouldn't be able to be an arbitrator if you were advising a particular club or player at that same time. Premier League, as I said, there's this implicit rule that if you're appointed to the panel, then you cannot appear in front of the panel. English Football League, again, no express rule. I am regularly counsel, arbitrator, co-respondent, in different guises. And then CAS, a very brief discussion I had with Jeff on the way in. Prior to 1st January 2021, if you are a CAS arbitrator, you shouldn't appear as CAS counsel. But it was only 1st of January 2021 that they changed that to include acting as an expert. Because, for example, the the case that Paul is going to discuss, the RUSADA and WADA case, experts for both sides were in fact Swiss CAS arbitrators. Shortly after that decision, this rule change happened. So that's a whistle-stop tour, ladies and gentlemen. I hope I've given you an overview. I'll finish off where I started. There is no one-size-fits-all, and you might find that slightly surprising, but that is a brief introduction to the world of sports arbitrations. Thank you very much.
Thanks, John. We are now moving from the broad outline that John just gave us in terms of sports arbitration to a procedural issue that will be outlined by Dr. Leanne O'Leary. Leanne is a senior lecturer in law and a dual qualified solicitor in New Zealand and England and Wales. She completed her university education to master's degree level and commenced practice in New Zealand before moving to the UK. In the UK, she practiced as an employment solicitor and completed her PhD at Trinity College in Dublin. Leanne's research interests focus on alternative dispute resolution and the intersection of sports law and employment law. She is currently a co-investigator in the European Commission-funded Employees Project that is evaluating good governance and athlete relations in Olympic sports in the European Union, Norway, and the United Kingdom. Leanne has published in leading sports law and employment law journals, including the Industrial Law Journal and the International Sports Law Journal, and a fellow of the Chartered Institute of Arbitrators, and an arbitrator at the Court of Arbitration of Sport, CAS, in Lausanne. She is also a member of the Sports Resolutions Panel of Arbitrators and Mediators in London, and is an adjudicator with the Center for Effective Dispute Resolution, also in London. I think it's clear that Dr. O'Leary is an expert in sports law, and she will now give her presentation on switching teams mid-match. Thank you.
Thank you, Alina, and thank you, Mel, for that introduction. Earlier this week, I was in my office near Liverpool and not appreciating that by the end of the week I would be here in beautiful Cambridge. So I'm delighted to be here and also to be a part of this wonderful panel, and I thank the organisers very much for the opportunity. I thought that in light of that, the approach that I would take would be to discuss an issue that arose in a case with which I was involved. These are tentative ideas, they are preliminary thoughts on an issue that I think has practical significance, but also I think is academically interesting. It relates to the principle of estoppel, as it would be, as we would know it in a common law jurisdiction, or in Swiss law and other civil law jurisdictions, and please excuse my Latin pronunciation, it's venire contra factum proprium. And the issue is whether that particular doctrine should be accepted in CAS arbitration appeal proceedings with the effect that a party to a CAS proceeding, specifically an appeal, can be stopped from arguing a different version of the facts to that which they argued at a first instance hearing. So I'm going to discuss the tension that can exist between the de novo hearing provisions within the CAS Code of Sport-Related Arbitration and a little bit about the estoppel doctrine. And to do that, I'm going to use a case example, because often with procedural things, it's a lot easier to follow it through with an actual case. So let's start with the case of Party A versus Party B. And in this particular case, in the first instance disciplinary forum, Party A argues a particular set of facts. Those facts had a meeting occurring on a particular date. The actual meeting date wasn't so important in terms of a breach of the sports regulatory rules, but the date was important in terms of interpreting or setting some WhatsApp message exchanges and documents that followed in context. Unfortunately for Party A, at the first instance, Party A loses, and there are disciplinary sanctions imposed, whereupon Party A decides to appeal the sanctions to CAS. and files a statement of appeal to commence the proceedings under Rule 48 of the CAS-related Code of Arbitration for Sport. And within that particular statement of appeal included a stay application. So wanted CAS to stay the execution of the decision that was being appealed against and the disciplinary sanctions. Within those documents, Party A relied on the same facts, so the same meeting date, the same WhatsApp exchanges. Party B resists the stay. Party A loses. And then Party A discovers some new evidence that changes the factual chronology and moves the date of the meeting to several months earlier. And whilst that's not overly important, as I mentioned, within the regulatory framework, of course it changed or coloured the context in which the WhatsApp messages and exchanges occurred. On the basis of that, they then applied for a second stay of execution and were not successful. Party B resisted the stay and Party A loses. So Party A is not having a lot of success so far in these proceedings. It then comes after losing the second stay, the parties then agreed to an expedited hearing. And Party A filed the appeal brief and exhibits and included new evidence. And Party B filed the answer, and lo and behold, first argument is that Party A is precluded from arguing the defence based on the factual change. And to do that, Party B relies on venire contra factum proprium, or as we would know it, the doctrine of estoppel. So at this point, it's important to highlight another unique, well not so much unique, but distinctive aspect of CAS proceedings, and that is Article Rule 57 of the CAS Code, which is that the panel has the full power to review the facts and the law on appeal, to issue a new decision, to annul the decision, to refer the case back to the first instance tribunal. So it is a de novo hearing. And in addition to that, the panel also has the power to exclude the new evidence if the evidence was available or could reasonably have been available to the parties before the challenge decision was rendered. So if this new evidence that Party A was relying on had been available before the first instance disciplinary hearing, or could reasonably have been available to that particular forum, then the CAS panel has the power to exclude that under Rule 57. In terms of exercising that power, though, it is typically exercised cautiously because, and this is relating to the fundamental principle that on appeal, that it is a de novo hearing. So usually it is limited in terms of whether evidence or new evidence is excluded. Okay, so let's then return to the Swiss doctrine. And in common law jurisdictions, this particular doctrine has been given a number of different labels. So it would be referred to as judicial estoppel in the US. In the UK, we would know it as the doctrine of estoppel by conduct. And generally, it's considered, or many purposes to it, one of which would be to prevent the abuse of the judicial process, and the other would be to protect a litigant's oath. Under Swiss law, it's defined as there on the slide. So where the conduct of one party has induced a legitimate expectation in another party, the first party is stopped from changing its course of action to the detriment of the second party. And it has been invoked to invoked within CAS authorities. These are four, so at least 4 occasions it has been invoked. The first 2 I'm not going to go through because they relate more to a contractual setting, not necessarily related to procedural. But the final 2 relate to procedural, and they are relevant to this particular case. So in FK Seneca, the 3rd bullet point down, that particular club wanted to bring a claim before the FIFA DRC, alleging that they were entitled to training compensation. And under the rules at the time, FIFA declined to accept the claim, and FK Seneca then appealed that particular decision to CAS. For a number of reasons which aren't explained actually in the decision, FK Seneca didn't proceed with the appeal, it withdrew it. So one appeal which it wanted to bring, it subsequently withdrew before there was a decision made on it. And then 2 years later, it applied again. So it applied to appeal the decision. And in that particular case, the sole arbitrator relied on the Swiss doctrine and considered that FIFA had a legitimate expectation that the matter had been resolved by the withdrawal of the first appeal, and characterised the situation as res judicata and refused the second appeal. In the fourth case, the Kali case, that concerned a professional player who had brought a claim against his former club alleging a unilateral breach of the player's employment contract without just cause because the club had failed to pay the player's wages. Before the claim was brought in the FIFA DRC, the player entered into a settlement agreement with the club and accepted a lesser amount. The club, though, failed to honour the settlement agreement, whereupon the player brought a claim in the FIFA DRC for the entire amount that was due under the original employment contract. The decision in the FIFA DRC was to award the amount that was that had been agreed under the settlement agreement, and so the player appealed it to CAS. It goes through the CAS procedural exchanges, documents being filed, and then on the day of the hearing, the player's representative says that it is not Swiss law that it has previously indicated in its documents it should apply, but it's actually English law that should apply to the settlement agreement. These parties had no attachment to England and Wales. The lawyers were not from England and Wales, but the settlement agreement, they alleged, was subject to the law of England and Wales. The reason being that the type of agreement it was we would have considered that as what was a compromise agreement, and it would have been declared invalid because it hadn't fulfilled certain statutory conditions in relation to what was then compromise agreements and are now known as settlement agreements. In this particular case, the sole arbitrator rejected that argument, and the reason effectively stopped Kali from being able to continue with the argument, I guess, is another way of putting it. Mainly for two reasons. One, if you, after you have filed your appeal brief and the answer, if you want to introduce new information or new legal claims, then you actually need the permission of the arbitrator in order to do that. And that's set out in Rule 56 of the Code. So that was one reason they hadn't sought permission to introduce this new legal argument. And the second reason, of course, was relying on the Swiss doctrine, because the arbitrator considered that there had been a legitimate expectation based on the documents that had been filed that the law that applied to the settlement agreement would be Swiss law and not English law. So that brings us back to the situation of the current case and the example, and also just a general consideration as to whether this particular doctrine ought to operate in or should operate in CAS jurisprudence, specifically in relation to factual changes. Because CAS is an arbitral tribunal, it's not bound by what's happened in the past. It's not attached to sports tribunals in a hierarchy similar to states' courts. And there is a tension between constraining the parties to what they've argued in the past and the power of de novo review and that lower threshold for accepting new evidence. So what are the reasons in favour of accepting this particular doctrine? Well, if we relate that back to the case, Party B had a legitimate expectation that the appeal would be prosecuted in a particular way. The facts had been argued in a particular way in the first instance. They had been argued or presented in a particular way in the statement of appeal, and then also in the stay application. it would be procedurally unfair to enable Party A to change its stance. And the detriment that Party B would suffer would probably be in terms of cost and time and having to change its argument and argue based on a new set of facts. The argument against accepting it is that that would be inconsistent with this de novo power of review, and that there can be occasions where there is no procedural unfairness. For example, Party B, you could say, had the full opportunity to respond to the new facts in its answer, including to the credibility and weighting that attached to that new evidence. And so there hasn't been any violation of the right to be heard. And so in that regard, and that's pretty much bring me to the end of the presentation. I needed a concluding slide. The purpose has actually just been to highlight that tension between this de novo power of review and arguments of estoppel, and perhaps consider or canvass views as to whether this doctrine should apply, and if so, in what circumstances.
Thank you, Leanne. I'm sure that members of the audience are probably thinking of questions that they might ask you later about that. I did. But now we move on to Paul Gilroy, who is going to be talking about the Russian anti-doping scandal and whether the CAS panel was too lenient. Paul Gilroy, Queen's Counsel, is a barrister practicing from Littleton Chambers in London, like John, and he was appointed to Silk in 2006. He is renowned for his employment law, general arbitration, and sports law practice. And in sport, this covers advisory work, litigation, arbitration, all regulatory aspects of sport. In other words, Paul does everything in sport. His experience covers football, rugby union, rugby league, cricket, tennis, cycling, boxing, athletics, weightlifting, gymnastics, and table tennis. And he has extensive experience in issues relating to selection, non-selection, anti-doping, and safeguarding in sport. He has appeared before and chaired arbitral, disciplinary, and regulatory bodies in a wide range of sports. He has advised and acted for a stellar list of clients from the world of domestic and international football, and that football practice covers the High Court and arbitration proceedings, principally FA Rule K8 matters, and proceedings before the Premier League. He also has the most experiences as counsel before Premier League Managers Arbitration Tribunal. In other words, he knows a lot about football. With that, I introduce you to Paul Gilroy, and he will give his presentation. Thank you, Paul.
Knows a lot about football, but doesn't know how to work a computer. Doping in sport is corrosive. Modern sport is corrosive, but as we'll see in a moment, it has had that impact over the years, ever since sport was invented. The ancient Olympians did not have performance-enhancing drugs at their disposal, but as we can see, law, oaths, rules, vigilant officials, tradition, the fear of flogging, the religious setting of the games, a personal sense of honour, all of these contributed to keep Greek athletic contests clean. That's going right back to the very beginning of the Olympic movement. And my talk this afternoon is in relation to, I think, what is universally accepted to be the Russian doping scandal that came before WADA and subsequently CAS on appeal. And the reason why it is a scandal is because of the factual features of the case, it being a state-sponsored programme of doping in sport. I sat on the anti-doping panel, the National Anti-Doping Panel, for 5 years. I've always likened anti-doping to almost like drink driving in the criminal sphere. It's a strict liability forum. No question of intention and motive and mens rea. It's a very strict liability venue and forum, and it is taken extremely serious in the case of each individual. But here, in this particular case, state-sponsored endemic corruption in the sport going to the very highest level, and I mean the very highest level. I'll show you what I mean by that by a slide in a moment. But let's look at the problem that we're dealing with here. Thomas Hicks won the 1904 Olympic marathon. He was assisted with brandy and strychnine, Olympic champion. In the 1970s, an American physician, Gabe Merkin, posed that question. If I could give you a pill that would make you an Olympic champion and also kill you in a year, would you take it? And that was posed to elite athletes. So I'm going to throw it open to the audience. Give me a figure, give me a percentage. Someone throw out a percentage of how many elite athletes answered that question in the affirmative. Any takers?
70. 60.
60%. That's what you're dealing with. And that's the 1970s. And there was a similar survey done at the Montreal Olympics in 1976. Similar sort of question. Bob Goldman, another leading figure in this area, similar question. If I've got a magic drug, if you took it once, you'd win every competition you would enter, from the Olympic decathlon to Mr. Universe, for the next 5 years. But one minor drawback, it will kill you 5 years after you've taken it. Would you still take the drug? Straw poll again from the audience, please.
Even more.
Same answer. So that is what I would put under the heading, that is what you're dealing with. Now, that is not a flippant, how could one be flippant about that, given what is happening in Ukraine as we speak? The reason that is there is because the findings of WADA that were not disturbed by CAS were of a corrupt practice that went right to the very top of the state. And if you read into the background to the Sochi Olympics in 2014, the person we can see in the front of that photo was not only instrumental in the arranging of the games and all of the aspects that go with it, he even involved himself in the selection of the venues. Every single detail he was involved in. So I would suggest there is a reasonable inference that can be drawn, especially when you look at the WADA findings in particular that were not disturbed. This was something that went to the highest possible level. So it could not be more serious for sport. The whole principle and ethic of sport is fair competition on a level playing field, where we expect, as the spectators, the highest level of fairness and the Corinthian spirit, whatever sport it is, and to have the thought that someone has done something that places them in a position of advantage, that replaces all of the training regimes with some sort of chemical input, is so corrosive that it fundamentally destroys all trust in the sport, whatever the sport is. So, the anti-doping scandal in headlines. After Sochi, evidence emerged of wide-ranging doping by the Russian team. There were investigations. WADA became involved. Independent anti-doping investigators became involved. We started to see the evidence emerging. You can see on the final bullet point on the slide. This is officials. It's not competitors or athletes. Officials fabricating evidence. So these are the people who are the guardians of the system. Fabricating evidence, deleting data and backdating computer systems. WADA, therefore, in December 2019, issues the ban. It's for 4 years, and RUSADA, the Russian anti-doping agency, appealed to CAS. The bulk of WADA's findings upheld, including findings that RUSADA was non-compliant with the World Anti-Doping Agency Code, but the sting in the tail, 50% cut in the penalty. What I will talk about very briefly, because time is limited, is the particularly surprising background to that decision. Because if you again read Cass's findings, rather like the disappointed lawyer who loses a case on a technicality, you will read all the way through the decision and you would not believe the number of arguments that were mounted by Russia and RUSADA to defeat this ban. Technical arguments, application of civil law, was it Swiss law, you name it. Get the manual out, it was all there in the skeleton arguments. And Cass went along with it. Cass said, we agree. This is an absolute outrage and a scandal. But by the way, we're going to reduce the ban for 2 years. And as I will say in due course or in a moment, that has had a fundamentally undermining effect on the whole of the anti-doping regime as it is across the world. So, in a little bit more detail, so we got Sochi in 2014, then the German documentary came along the next year called Top Secret Doping, How Russia Makes Its Winners. A WADA commission found a deeply rooted culture of cheating in Russian sports, and again, emphasis there as to the sheer tentacles of this conspiracy in the sport. State officials, RUSADA, the police, the drugs police in that country, the Ministry of Sport, and all of Russia's athletic federations. Hard to imagine. It could be more serious, but just in case you hadn't noticed how serious it is, intentional destruction of over 1,400 lab samples after WADA had asked for them. The IOC did not react particularly adversely to this state of affairs. The IOC refused to ban all Russian athletes from Rio 2016, and it left it to each sport's international federations, you will remember simply as followers of sport. It was left to individual federations to determine individual athlete eligibility, and there's a quote from Thomas Bach, the then IOC president. We've set the bar to the limit by establishing a number of very strict criteria which every Russian athlete will have to fulfill if he or she wants to participate at Rio. You will remember that led to the participation in the Games of people without a flag, those who are able to establish their eligibility. We then move forward to a second WADA investigation by Professor McLaren. Again, the lab in Moscow, WADA accredited, operating to protect doped athletes. And again, I mean, if you had to write this and make it the most extreme and egregious case, it's hard to imagine that you would invent facts more serious than this. 1,000 Russian athletes in 30 sports, a state-sponsored programme, all of them benefiting in that, and it was of several years' duration. So there's a bit of chronology there. The IOC puts in sanctions. Russian athletes not previously accused were allowed to compete, and there was a ban for life on the Deputy Prime Minister of Sport and a $15 million fine to pay for the doping investigations. And it was the first time the IOC has suspended an entire nation from the Olympics for doping. In 2018, WADA voted to reinstate RUSADA on condition that they turned over unadulterated data from the Moscow laboratory. So the, John will tell you I love football analogies. The yellow card is administered and firmly flung back in the face of the referee, because RUSADA, having been given this opportunity, failed to fulfil the requirement, and that was held by WADA to be an act of critical non-compliance under the code. It's hard to imagine how that finding could be criticised. So not only have you got this terrible thing going on, you've got clear evidence of an attempt to cover up the cover-up, including, again, manipulating test results, backdating the old computers, and falsifying messages to incriminate the guy who was blowing the whistle. Dr. Grigory Rodchenkov, who should have a statue made of himself for the courage that he demonstrated in taking on the Russian authorities. And that was his reward. It was said that he was essentially corrupt and he was manipulating, and it was all a private scheme by Dr. Rodchenkov to extort money from athletes rather than being part of a centralized doping and anti-detection scheme. So the yellow card is flown firmly back in the face of WADA. They issue the red card in December 2019, a ban from international competition for 4 years, excluding it from the 2021 rescheduled Tokyo Games and the 22 Beijing Summer Games. Athletes only compete as neutrals, only if not implicated, and various other associated bans on officials, even to the extent of not being able to attend Olympic events or major sporting events. Can't host or bid sporting events, and again, all of the costs had to be paid by RISADA. The appeal to CAS is, in terms of its bulk of argument, encyclopedic. It would take a week to deliver a talk on what the submissions were. But here are some sample arguments. No one deliberately manipulated the Moscow lab data. Even if they were manipulated, third parties outside their control were responsible. One hell of a job. They managed to come in and do that. There it is. And one of my favourites, breach of the European Convention on Human Rights. You see, when you've got state-sponsored doping, it's unfair to the individuals for them not to be individually represented and heard. Superficially attractive for about 10 seconds. And the WADA sanctions infringe the principle of proportionality, exceeding what was necessary to achieve the legitimate purpose of fighting doping. Now, advocacy involves taking on some tough challenges, but whoever had to stand up and say that in front of CAS might be able to say, I had a bit of a hospital pass. December 2020, a 4-day hearing, never ceases to amaze most English lawyers about how short these hearings are. If it was left to the good old English common lawyers, we'd be there for months arguing the toss about this. The importance of the case, a 4-day hearing, 50 intervening parties. I don't think I've ever witnessed a case with 50 intervening parties. I've done class actions, but not 50 intervening parties, all having their say. And here we go with the decision. And this is what I was saying earlier about the surprising nature of the overall conclusion, because all the way through, you have CAS accepting what WADA said. Non-compliant with the code, strict liability for any data manipulation. RISADA must pay 1.27 million US, do everything possible to locate authentic data, and I've put some specific quotes in. Far from recognising the opportunity to come clean and draw a line under a scandal that has plagued and drained resources from international sport for years, the Russian authorities unfortunately saw it as an opportunity to fraudulently promote their fabricated defence strategy and mitigate or avoid the consequences of the doping scheme. Now, those of you in the audience who are law undergraduates, moving on, as you undoubtedly will, to glittering careers as legal professionals, certainly when you are in the sphere of litigation, for any court or tribunal to find fraud is an extremely high bar to be established. So one cannot imagine a more serious finding by an appeal body. Non-compliance could hardly be more serious, interfered with and undermined the system in the most cynical and sophisticated manner. Robust action required. Authorities remain as willing as ever to interfere with and corrupt the anti-doping system, having done so in the past in a manner previously considered unthinkable. It's unnecessary to take robust action to deter any repetition. And 711 of the decision, necessary to impose serious consequences, etc., etc. So Russia reinstated 16th of December 22 rather than before Paris 2024. So I have very limited time. I've already been given the indication that I'm about to be given the shepherd's crook. My thesis on this, my theory on this, despite the presence on the panel of 2 members of CAS, didn't tell me that before I agreed to do this talk. What are the talking about Valieva? Yeah. What are the flaws here? Well, where do you begin? Shifting the burden from athletes to prove their eligibility onto WADA to prove their ineligibility, eliminating certain criteria to prove they're clean. That is a recipe for disaster. That is going to result in people who are serial defendants or serial suspects in doping to repeat their behaviour. Panel not persuaded an exclusion, placing the onus on athletes to prove they were not implicated, would be appropriate. Well, 2 words to that, why not? So I've run out of time. I've put some quotes in here of those who would be expected to know about this sort of thing rather than me. And I defer to them and their expertise. A catastrophic blow, blatant disregard shown for the rules and the purpose of anti-doping regulation. It has harmed clean athletes and gone further to erode confidence in the international anti-doping construct. That's the US Olympic and Paralympic Committee. And perhaps most important of all, poor old Dr. Rodchenkov, through his attorney, the decision to effectively split the baby is nonsensical and undeserved, despite overwhelming proof of corruption, doping fraud and obstruction of justice, including a brazen attempt to falsely incriminate Dr. Rodchenkov. CAS has once again proven itself unwilling and unable to meaningfully deal with systematic and long-standing criminality by Russia. So that is my personal view. I support that view. I don't support the view that CAS is a serial offender as far as these matters are concerned. I focus purely on the parties to the proceedings, Russia and RISADA. It is a scandalous episode in doping in sport, and it is one that one hopes will never be repeated.
That's all right. Well, things are getting interesting. I wonder, when we have questions, whether one of our members of our panel might have questions for Paul. But for now, we continue with the presentations, and we are now turning to 2 gentlemen who not only are great sports lawyers, but also were former athletes. The first is, I turned the wrong page, is Udo Onwere from Bray Krais. Udo was previously a professional footballer for 12 years with several clubs, including Fulham. Now, he leads the Bray Krais private client and sports offering. Building on his sporting background, Udo advises high-profile sports individuals, particularly professional footballers, managers, and directors, on all areas of private client matters and general commercial issues. He has experience advising individual sportsmen and/or their agents on contractual negotiations and content, and has acted as a trustee for the Fulham Football Club Foundation and the prominent anti-discrimination organization Kick It Out. He is also currently a judicial panel member on regulatory and disciplinary issues for the Football Association, covering all aspects of sports arbitration within professional football. In addition to above, Udo advises a number of clients with their own businesses. He is a member of the Society of Trust and Estate Practitioners and was appointed director of the British Association of Sport and Law. And that is an association which represents sports law practitioners, sports administrators, and sports law. With his football background and his football law experience, no wonder Udo will be speaking about an insight into the Football Association arbitration panels. So I would ask you to welcome Udo to the stage.
Thank you very much, Mel. Welcome, everybody. Good to see you all here for attending. I thought with my talk, I'm going to bring it a bit closer to home in terms of me talking about the arbitration process from the UK perspective. We've had a wonderful international flavour from the speakers so far, but I'm going to be bringing it a bit closer to home and talking about the work that goes on here in the UK. So I'm going to be talking about the FA judicial panels. The procedure, I've got two things I'll be talking about. First, I'll be talking about the procedure. And secondly, there'll be a case study that I will speak about at the very end of a case that I was actually involved in. It was quite interesting in terms of some legal aspects to it and also its ramifications going forward. Before I start, just in light of some of the brilliant questions that were thrown to the audience already, I wanted to ask anybody here, who of you have seen, if you're sports watchers, it would say Jurgen Klopp or Pep Guardiola has been banned by the FA for comments made to a referee after the game. Has anybody ever seen something of that ilk? Show of hands, we've got one here. Or there's a few of you. Or it may say Liverpool or Manchester City or Chelsea. The club has been fined or is going to receive a sanction for failing to control its players. If you've ever wondered, I wonder who actually sanctions these people or who's involved in that. Well, you're looking at one of the people here. So if you ever see that, please don't hate me too much. But just to talk about the personal hearings themselves. So just going to go through the slide. The important things to remember about personal hearings, which is the procedure for FA judicial hearings, are there are sort of three main parties involved. The first would be the regulatory legal. The acronym they're given is RL. Regulatory legal are the equivalent of the sort of CPR in the legal perspective in terms of they're the ones who are the in-house lawyers for the FA who actually bring the charge and present it to be evidenced. PC, participant charged, in effect, that will be the players. But participant is given a very broad definition, and that includes all types of people who are involved in football, from managers to include agents, coaches. It might include some referees sometimes. That's been the case. So it's a very broad definition that's given to participant. And then last will be the Regulatory Commission, which, as I said, that I would be on that myself. And there will be other members who are legal professionals who will sit on the commission, and their job will be to look at the evidence of the case and to provide some clarification on what goes on. So the process, as you can see, it will follow a usual kind of process that you get with court cases where regulatory legal will bring call their witnesses and bring their evidence, and they'll be given the examination in chief. The representatives acting for the participants will then cross-examine, and it will then go back to regulatory legal, who will offer a re-examination, and then it'll be our job as the Regulatory Commission to provide some clarification and assistance to it. As much as we like to, as a Regulatory Commission, as much as we like to get involved in trying to ask questions, our job is mainly to assist. The questions are always asked by the representatives, either the regulatory legal or the representatives acting for the participants that are charged. So you can see by this slide, the participant charged will then be given a chance to present their case when they're rebutting the charge, and it will be the similar procedure as I spoke about on the last slide. So, excuse me. So once the evidence has been completed, both sides have had an opportunity to present their case. We then, as a regulatory commission, will give the regulatory legal a chance to sum up. The participants charged are then given also a chance to sum up, and they're given what we call the last word, because again, we're looking at the fairness. But this is not an opportunity for either side to bring new evidence. When I've sat on cases before, sometimes you find, especially where you have the participants charged who may not be that experienced on these processes, tend to come with a whole new raft of evidence. That's not the case. We're very strict on that, that the chance to bring your evidence is when it can be cross-examined. Once all of this has been orally submitted, all of the parties will leave the room. And just one more thing, I just forgot to mention that normally these cases are heard in very salubrious rooms at Wembley Stadium. In case you're thinking it's some grand courtroom, it's actually held at the home of football at Wembley, which in itself is quite nice as well, I think. But it gives us an opportunity to provide everybody with, especially the participants, an opportunity to come and present their case. So they vacate the room. We are then left as a regulatory commission with an opportunity to deliberate. Now, the important thing to remember here is that the balance of probability is what is looked at as being a civil burden of proof. And that means that we have to find, as a commission, whether we find that the charge was proven, whether it happened more likely than not. So we're looking at the findings of fact, and we're given a reasoned determination of why we've come to that decision. Normally, there are 3 of us that will sit as a regulatory commission, and that will mean that we have 1 equal vote, which means you either have a majority or a unanimous decision. Parties are then brought back into the room. If the charge is proven, the decision is announced. That's when you normally get all of the emotion. Chairs are thrown around the room, only joking, but you always get quite a bit of emotion at that point. The person who is the secretary, the person who's doing all the admin in the courtroom, will then give everybody that's within the room the previous history of the person who has been proven, had the charge proven against them. It's at that point that the parties will then again leave the room, and we will then deliberate further on sanction. Just one small point, that if, of course, the charge is not proven, then that's the end of the hearing. Just a small slide that I thought I'd include here with these personal hearings, that sometimes you have very odd issues that can occur from time to time, where you may ask one party to adjourn because they're not feeling too well. Sometimes we have to look at that tactically, that especially if a club has been charged, they may want to adjourn the case because they may want the player to appear in the next game or something like that. So we have to be very alive to all of these things, and these are just some of these sort of various occurrences that will happen. So coming to sanction, the charge has been proven. We, as a regulatory commission, then have to look at sanction, which is we are looking at what we're going to apply in terms of whether the individual or the club will be banned for a certain amount of matches or whether they'll be fined. We will look at aggravating and mitigating circumstances, and we will look at other things like suspensions, which will mean that if the party who has been charged, if we are worried that there's not going to be any compliance with our charge or our sanction, we then have to look at whether we may need to increase the penalty against them to deter them from doing that. This is just a small point on costs. Whoever loses the case will be liable for the costs, and that can vary. There's no formal guidance on what that is. That varies from time to time. But some of the things that we look at when we look at costs are whether the charge was admitted or denied, whether the charge has been proven. We look at the participants' means and also the level of the game. As you can imagine, we're not just dealing with Premier League footballers, we're also dealing with players who are playing much lower league, lower down. Some of them will be playing in the non-league as well, so we have to consider all of these things in a round. One other final point, after the hearing, it will be our job as a regulatory commission to look at preparing what we call written reasons. And this is actually quite relevant in the case study that I'm going to speak about at the end, because this is the point where we have to provide our reasons as to why we came to our decision. It's a bit of a play on the justice not only needs to be done, it needs to be seen to be done, which I think is a dictum that's been down the ages with a lot of court cases. So just one small point that I wanted to raise with you, which is to do with the applications of the regulations. As a regulatory commission, this is a bit of a twist on what we're talking about today, because as you can see, Regulation 4 says, the bodies subject to these general provisions are not courts of law and are disciplinary rather than arbitral bodies. In the interest of achieving a just and fair result, procedural and technical considerations must take second place to the paramount object of being just and fair to all parties. So in a nutshell, we are not arbitrators as such. Our role is to make sure things are fair and just, and so we are looking at things in a round. This is talking about us as a regulatory commission. Lastly, appeal considerations. If the party or the participant charged isn't happy with the decision, they're allowed to bring appeals, of course, and some of the things, as you can see, that they'll look at us as a regulatory commission that we misinterpreted or failed to comply with the rules, or we came to a decision which no reasonable body would have come, and various other things that are there for you to look at. So, coming on to the case study. So, we are going to talk about a case that I was involved in, happened last year, and it was involving a young player at Middlesbrough Football Club, Mark Bowler. So this is to do, some of you in the room would have heard about these sort of things that happen with historical tweets. So Mark Bowler, young player, he was charged with a misconduct rule in respect of a post of a tweet that he posted in 2012. The player was 14 years of age at the time. Now, I don't know about anybody else in the room, but I would rather shrivel and die than think about some of the idiotic things that I did when I was 14. So this was one of the major considerations we had to look at when we looked at this. However, the tweet itself, as you can see with the quote given, we described it as being deeply offensive and would have caused considerable revulsion and distress to those who read it. That is particularly so, and this was the aggravating factor, particularly so where the tweet had endorsed violence against gay people. Now, the rule that we were looking at was the Rule E3 of the FA regulations, and this is a very broad, all-encapsulating piece of legislation that seeks, I'll just look at the last two sentences of the first paragraph where it talks about any combination of violent conduct, serious foul play, threatening, abusive, indecent or insulting words or behaviour. So it encapsulates quite a wide range. But this rule itself is aggravated, and you can see the paragraph underneath, where, again, looking at the last couple of sentences, where there's a reference to ethnic origin, colour, race, nationality, religion or belief, gender, gender assignment, sexual orientation or disability, and the list will continue to grow. Mainly to do with public sensibilities and the way that the politics works within society nowadays, the FA finds itself constantly having to, shall we say, redefine legislation. So our position with Mark Bowler in this case was that we had to consider what the legislation was in 2012 when the offence happened. Now, the offence at this time, just to give a brief summary, was that whatever the Regulatory Commission was in dealing with the case, they had full discretion on how they were going to deal with the breach of E3. And I'll come to that, why that is so relevant in a minute. So the guidelines for the Regulatory Commission was that in 2021, which is when we were looking at the case, was that the guidelines had then changed. The Regulatory Commission no longer had full discretion, but now we had to apply a minimum sanction of immediate suspension of 6 to 12 matches. So if we found that this tweet that Mark Bowler had submitted when he was 14 years of age, if we found that the FA charge was proven, we would then have to apply an immediate suspension of 6 to 12 matches. We would look at the aggravating and mitigating factors involved, but in effect, our hands were tied. We wouldn't have anywhere to go. So some examples of aggravating and mitigating factors. An aggravating factor is repeated use. If Mark Bowler had repeatedly sent out these tweets, we look at the profile and participant of the profile of the participant. So, for example, if the participant was a person who had seniority within a football club, we look at any premeditation, which is self-explanatory. Some of the mitigating factors would be that there'll be an illegitimate expectation of privacy. Maybe if you send out a tweet, you didn't expect that it was going to be brought to the public attention. It was just done between friends. Admission and remorse would be a mitigating factor. Inexperience is the big one at the end, due to age and background. As we said, Mark Bowler was 14. So, the really interesting thing with this case, 2 points. The first was the principle of lex meteor that was brought by Mark Bowler's representatives. And the second was the fact that we had to do some redactions to our written reasons. I'll come to the second point in a minute. The first point, lex meteor. For the classicists amongst us, lex meteor, Latin phrase, literally means milder law. And the argument that was brought by Mark Bowler's team was that the law at the time when the offence occurred should apply to the offender now because it would be more favourable to the offender. So if you remember going back to the 2012 legislation at the time, the Regulatory Commission had full discretion. We were not tied to 6 to 12 matches. We had full discretion. And that was the argument that was brought by Mark Bowler's team. The FA, if you see the second bullet point, agreed that lex meteor applied, but the FA was still of the mind that the 2021 legislation should apply. We didn't agree with that. Third bullet point, we agreed that lex meteor applied, and therefore the 2011-2012 guidance was the appropriate approach. There was no mandatory sanction, and we would have full discretion on how we would deal with the player. We then, therefore, found in our deliberations that the player was just to be the player was just going to be warned as to his future conduct. We then said he also had to attend an FA education course and he had to pay our costs because we looked at everything. We looked at the aggravating and mitigating circumstances. We looked at his age. We looked at everything else like that. We found that he was sufficiently remorseful. We looked at the sort of arguments that he brought and how it would affect his life. And so that was our decision. That's what we came to. We then had to apply all of our reasoning in what's called written reasons. So, looking at the principles for our written reasons, what came about from this case was that it's not for the Regulatory Commission to decide what is in their... it is for the Regulatory Commission to decide what is in their written reasons, not the FA. We could not be pushed into any direction by the FA how we were going to determine our decisions. It was down to us. But it was up to the FA to decide whether the reasons were published. And this was a really big factor in this case. As well as the lex meteor principle, it was whether these reasons were going to be published. That's what the player was really concerned about. He did not want the exact phrase or the wording that was used in his tweet to be published because he said that it was going to affect his family life, his professional life, and his personal life. The FA left it to us to decide whether we were going to publish the tweet itself. We decided that we were not going to publish the tweet in its entirety, and we decided amongst ourselves that we were going to give a very small and very summarised edition of what was said. So this is the final slide. So part of the reasons why we decided to very much reduce the tweet is that if you look at the second slide, second bullet point, we found that the mere prospect of adverse public reaction was not of itself sufficient. We were concerned that if the tweet was given public hearing in its entirety, that it would affect the player on such an extent that it would be unfair. So we had to look at his own personal circumstance, his mental well-being and everything else like that. So the effect, if you look at the very last or second to last bullet points, the effect was that the reasons that we published would not include a precise wording from the tweet. We described the tweet in a section of our reasons, and getting back to the point that I said that we're not an arbitral body, but we are looking at things that are just and fair. It was a balancing act. It was a balancing act in looking at whether we had to punish the individual for tweeting such offensive material, but at the same time, we had to make sure that there was a balancing act that was fair to him as an individual. It was a very unusual case because there's been other historical tweeting cases. I think some of you may remember one with a cricketer recently, and there's been other cases that have been of a similar nature. So this was a case that was not a precedent for future cases. It was something that was very unique. In the end, I think that the balance was struck, and the reasons are online if anybody's interested in having a look at that. And so it was a very interesting case, and I think that we came to the right result in the end. But the main point from our point of view was the deliberations we had to make sure that things were fair and balanced. So that's my very quick, brief summary of the role that I do as an FA panel member and of some of the interesting cases that we get, amongst many others that range from offences that happen between players on the field, managers speaking adversely about referees after matches, doping offences. There's such a wide range, but that's just to give you a very quick summary of how I work and some of the things that I do. So thank you very much for your time. All good.
I'll just keep talking. Yeah. Thanks, Udo. Our final panelist is Jeff Benz. Now, he gave me a little write-up about some of the stuff he does, and he insists that he does more than sports arbitration.
So much more.
He's so much more. But I will say this about Jeff. When I was trying to think of how to introduce him, I thought of a story that involves sports involving a gentleman named Jerry Rice. Now, Jerry Rice was a great wide receiver for the San Francisco 49ers. And when you go up before the NFL Hall of Fame, they usually have to argue and talk. They have a presenter that gives an impassioned argument that lists statistics and talks about what their contribution to the game was, and they then vote on whether that person should be in the Hall of Fame. Jerry Rice was so well known, and his records were so far above everyone else in the field of as a wide receiver at the NFL that legendarily, when he went up for the Hall of Fame, the presenter stood up and said, "It's Jerry Rice," and just sat back down. He didn't need to say any more. I don't really need to say much more about Jeff. I will say that, the BBC said that he is widely regarded as amongst the most experienced judges in world sport. The UK bar said that he's in a class of its own when it comes to sports disciplinary disputes. And you've probably read about him in the newspapers, and he admits that he got stopped on the street on the way, or was it the train on the way here? So I'm not going to say any more. It's about reflections of a CAS arbitrator. Here's Jeff.
Well, I've never been likened to Jerry Rice, but that's awesome. So I'm gonna try to stay on topic. Reflections of a CAS arbitrator. If you search right now, you'll find I'm in a very public fight with a certain boxing promoter named Frank Warren, involving the upcoming Tyson Fury Dillian White fight. I represent Dillian. If any of you have been sent here by Frank, or you represent Frank, or work with him, or know him, please tell him I said he should go screw himself. I am now doing that in every forum for a variety of reasons. In part to, he says Dillian's not promoting the fight. I'm promoting the fight that way in my own positive, negative way. You heard about CAS earlier. I'll try to keep this quick. When do I have to shut up for questions? Okay.
20 minutes.
Okay. So we heard about the closed list. Is it a closed list, or is it really a very, very, very closed list? It's about a 90-10 outcome is what it is. 90% of the cases get heard by about 10% of the list. It's been statistically shown by people that have analyzed the published field of cases. Why is that? People lament that. There should be more openness. You know who picks them mostly? It's the customers. The customers pick these people. They pick us because we're who they want for whatever reason. And there have been theories put out about why it's skewed that way and what it is. Ultimately, almost all of the selections, except for one category, come down to selection by the parties. On appeals, there is the opportunity for the CAS staff itself to pick the chair, and on original jurisdiction cases, the two arbitrators pick the panel chair. So if you don't like the outcome of who the who's are, you pick your people differently from the CAS list. The number of cases annually, see if I got it, there we go. The number of cases annually now, it's trending to nearly 900 cases a year, almost 1,000 cases a year. When you put this in the panoply of international commercial arbitration institutions, the CAS is about third. There's CTAC, which claims big numbers. Nobody believes them. They're a Chinese institution, and nobody believes their numbers. They're just doing it to stay ahead. Second, though, is the ICDR from the U.S., which is the AAA institution. It comes in. CTAC just puts up a number. You call it whatever it is, something with 1,000 on it. And then ICDR is coming in around mid-1,000s, somewhere in there. Usually, I haven't looked in the past year on their reports. The ICC is now neck and neck with CAS in terms of the number of cases it has. So think about that. Think about that as an opportunity for you as lawyers in the future and as a market for you later on, perhaps as an arbitrator. The mediation cases, when you ask about that, however, not so fun, not so easy. I'm not going to dwell on that, but when I keep asking how are they doing this year, they say, well, they've doubled, and that usually means it's gone from like 4 to 8. So think of that in the quantum of the grand scheme. I have a whole bunch of reasons for this. I've published on this. I view this as a growth area for me because I'm the only one talking about it. None of the Swiss lawyers like to talk about it. But they don't even know what it is, really. So I'm just trying to push this. But CAS has heard of over 8,000 cases since inception. I just got appointed to one that has a CAS case number on it with an 8,000 in front of it. It's going to be a very high-profile case. There's about 200 cases appealed to the Swiss Federal Tribunal under the Swiss Public International Law Act. CAS is an arbitral institution subject to the New York Convention in almost every case, so it's subject to review under the principles of the New York Convention. It's got a very high success rate in terms of avoiding vacature of its awards before the Swiss Federal Tribunal. It's funny because I get all the reports of the SFT in English. And there's so many of them that I mean, I think the Swiss Federal Tribunal has mandatory jurisdiction over these cases, and I would think they have much more important things to do than screw around about football cases, like what about seatbelts or what about car seats or something. But they take it seriously, and they're very involved in a number of these appeals, some of which end up being very high profile. The CAS has about 375 arbitrators. It goes up and down a little bit from a wide number of countries. The list is renewed every 4 years. John already answered the question, what percentage of the arbitrators are actually used at least once? The statistic commonly known as about half have been used once. So everybody wants to complain about the closed list. You know, there's a lot of arbitrators wondering why they don't get picked. They ask me what to do. I say, I'm tired. I'm trying all the time. I'm doing things like this so people know who I am. But that's how you got to do it. You got to market personal services just like you'll have to do it as a lawyer. And so the types of cases that we see, doping, football, I've been on all of these kinds of cases. I did a football case earlier in the week. I presided, and it was remarkable to realize that the two parties were Russian, represented by Russian lawyers in Russia. The appointed wing arbitrators, one was Polish, one was American, and the other one was from the Netherlands. And the Netherlands had just sent some deadly missile system into the Ukraine. Like, I mean, it was just like, wow, from a geopolitical standpoint. But it doesn't matter to what we do. We are country blind generally in terms of what we do. But that just kind of dawned on me. I wanted to have other conversations with the lawyers than about the case to see how things were going. But anyhow, we do eligibility and selections cases. How do I get to compete? How do I get picked to compete? If you see the CAS ad hoc division activity from the recent Beijing Games where I was at, almost all of those cases at the beginning especially, it was a record pace of these cases of people trying to find a way onto their respective Olympic team through allocations made by the IOC and the international federations for spots to compete in the games. Governance cases, lots of those. Sponsorship and licensing cases, a few of those. On the commercial side, the largest case I've had there had about 50 million euros in dispute. It was a sponsorship case involving the sport of cycling at a time when there was the beginning of morals clauses being introduced in these sponsorship contracts that would allow sponsors to get out if something bad happened with respect to the property that they were investing in. And there's a few other commercial types of cases that come up. So I'm going to try to cover how to operate the damn mouse. There we go. Okay, so putting it all in context, we're coming up at a time, pre-World Cup, I'll cover a case from the last one. This is very top level. It's meant to be fun. It's meant to be sort of war story-ish. So if you want to ask me about specifics, feel free. The great thing is, in this particular aspect, I can talk about some of these cases. I cannot talk about Valyeva because that's a unique aspect of the CAS ad hoc division. But all these cases are publicly reported. They're all out there, and there's nothing secret about it because we write it all down all the time in our awards, and those are published. So it's much better than the International Commercial Arbitration Ethics course I teach at Pepperdine Strauss Institute, which has no pictures. There's no photos, only a few war stories. I sometimes try to jazz it up with a few brown paper bags full of money and stuff, but whatever. So Paulo Guerrero, poo-poo, not getting a job in another sport with all those tattoos or any other job, really. Test positive for cocaine metabolites in small amounts. Everyone accepted that he tested positive because he drank coca tea. Okay, nobody disputed that. WADA didn't dispute it. You'll see in a minute why WADA appealed it. I don't know why I have Portuguese question marks on here, but whatever, that's cool. Fault analysis was the big issue. Proportionality was the big issue, and the punishment. So the only options for punishment at the time under the World Anti-Doping Code was a reprimand with no sanction. He could get 12 months to 24 months, or he could get 24 months. That's the decision tree. Count on FIFA to screw it up. The FIFA Disciplinary Committee, the first instance tribunal did the right thing. They were in one of the options. The FIFA Appeal Committee made up a sanction that's not in the range anywhere. WADA had to appeal this. They don't care about, really, they don't, cocaine, to take cocaine as a performance-enhancing drug, you're backward because you have to snort it so often, like you'd have to probably be running over to the sideline. Because it goes through your system so fast, and it's one of the most widely tested drugs in the world. It's a drug of abuse, and it's a workplace drug. That's where all the money has gone into testing, because of so much money can be made from doing those processes as a testing agency and as an inventor of how to test for cocaine. So WADA appeals. We issued a 14-month sanction, so we found some fault beyond the 12, there was fault for sure. He should have been asking questions. He basically was outside of the national team area of the hotel where the national team was performing in what you would call like the friends and family area. And somebody didn't put the medical analysis to the food that the national team usually gets inside the national team area. And nobody checked the tea. And he should have known because he's Peruvian and it's Peru and it's cliche, but it's Peru. He should have known that he had a chance of getting a coca tea. And so we found there was some fault for that. The SFT later suspended the suspension so he could compete in the World Cup. This is one of my favorite cases where if you're a lawyer and you don't take the cues you get from the tribunal, you don't actually listen, you do worse for your client. We had no interest in keeping this guy out of the World Cup. Nobody did. WADA didn't ask for that. They didn't ask for a hurried up decision. Nobody wanted this decision to get done fast except poor Paulo's lawyers. And they pushed, and we came back. The panel comes back like 3 times. You know, it's a ripe decision tree here. Maybe you want to talk about resolving this informally. Are you sure you need it? Next time, are you really sure you need it by Friday? Yes, we absolutely need it yesterday. Why the hell are you waiting until Friday? Okay. 14 months. He's out. And so I learned at the CAS hearing how many Peruvians live in Switzerland. Any ideas? Any thoughts? At least 92 because they were all outside the damn office. They all brought, a bunch of them brought dogs. There's at least 6 Peruvian dogs. They dressed them up. Oh, there's a famous arbitrator you'll hear about later. His name's been mentioned before already, but he was on the case with me, but I didn't feel it was fair to give him a profile photo on this particular piece. But there's one of the dogs. The people had a great time knowing that he wanted to have his photo taken with the dogs in the background outside. So I get this, because these cases are so public and it's sport and it's passionate, people want to reach out to you. People reach out to you. And so this guy on LinkedIn, Antonio Rig, he's general management and marketing strategy. He's probably unemployed. That's what that means as a title, just to read through the lines. And so he writes all this shit like, your decisions, whatever, blah, blah, blah. And I finally write him back when he says, can you please explain it back to me why your reasoning is any good? And I said, we haven't written our reasoning yet. We just issued the operative award. If you have a copy of it, can you let me see it? Because I kind of want to see it, Antonio. Oh, I'm sorry. 14-year-old students pounded me with like 35 emails from this class. I took it to my sons. I said, why can't you write a thought that cohesive? You're about the same age as these 14-year-old girls who are writing about soccer. They kind of screwed it up because somehow they brought Diego Maradona into the case, which had nothing to do with the case. But their one point in here was something like, I've waited my whole life to see Peru play in the World Cup. Peru hadn't played in the World Cup. I don't think it was 36 years. I think it was 24 years. These girls are 14. Do the math. Yes, of course you hadn't seen them play in the World Cup. So I get that stuff with video attachments and things about how great Paulo is. Then there's this. This is my favorite. This is the Lima Primetime News Drive Show. I hope the sound works. It's worth it. No. Dun, dun.
Das es la palabra que inundó nuestras conversaciones desde hace varios meses.
Any Spanish speakers in the room? What is Verdugos de Paulo?
The killers.
The executioners of Paulo, right? So this is my profile piece in Lima. And by the way, none of these people were at the hearing. This is stock footage from something else.
Organismo de arbitraje que resuelve disputas en torno al
None of
deporte.
those people.
Su sede se encuentra en Lausanne, Suiza. Fue creado
There are
en
some of my friends, but that's a
1984
different
por el
arbitration
presidente
panel.
del Comité Olímpico Internacional, Juan Antonio Samaranch, y es un ente independiente de cualquier organización deportiva. Está conformado por 300 expertos de 87
That guy I don't
países,
think was
pero
there
fueron
either.
3 los encargados de
There's
definir
Paolo,
el
there he
presente y
is.
futuro de Paolo Guerrero.
Dije todo lo que tenía que decir.
This guy
y
over
bueno,
here, be
ahora
careful of being
esperar
the
la
young
decisión.
lawyer in a high-profile case. He ended up getting fired right after this case and
Michael
works at
Beloff,
Netflix.
abogado inglés
So
de 76.
this is one of my fellow arbitrators, Michael Beloff. You heard his name mentioned earlier. He's a QC, one of the most prominent barristers in barristering. And this is his profile shot. It's him doing a debate at the Oxford Union. He at one point was president of Trinity College. I think there was a scandal because, I don't know, does Tony Blair have a dumb son? I think he let the dumb son in because he was friends with Sherry or something. I don't know. That was the scandal. But he's a great guy. He's one of my mentors. He came to my call to the bar ceremony. I'm on a new case with him, and we have a lot of fun. But trust me, I think on that case that John mentioned, he only got the result he did because he's Michael Beloff. The rest of us schmucks would have been hammered by the high court, I think. But anyhow, this is the profile of Michael. Look at
Fue quien
him.
presidió la audiencia de Paolo ante el TAS.
This is my intro. I got Maria Sharapova as
Jeffrey
my
Benz
intro. I
es
was
un
on her
ex atleta
case.
estadounidense
It will never
conocido
get
por
that
ser
good. I
parte
mean,
de
look
la
at that
corte que
big picture of
castigó
me
con
compared to
15
that.
meses a la tenista rusa Maria Sharapova en 2016.
This is the
Y un
nicest
italiano,
Italian guy. He's
Massimo
not really a
Coccia,
mafia
quien
don.
fue el juez
He's
presidente en
an
la audiencia
arbitrator, Massimo
representó a
Coccia.
Bolivia por el caso Nelson
He
Cabrera,
decided the
y que
case that
descalificó
allowed,
3 puntos a
it was
Perú
against
durante
Bolivia, I
las
think, that allowed Peru
eliminatorias.
to actually qualify for the World Cup. So he will get to see Machu Picchu. I will not get to see Machu Picchu the rest of my life, probably. So
Esta vez los abogados
that's what you can come to
internacionales tenían
expect in
3
terms
alternativas.
of having to be thick-skinned. This guy texted me out of the blue. I'm here to be found. I'm in a service industry. It's easy to find me. He starts off with 3, I don't know, kind of efforts at insulting me. Not too bad. They improve. By the last one, I want to start a heavy metal band. This is fantastic. It's grammatically proper, though not often used. It is some feedback as an arbitrator. You don't get that all the time. I don't get any of that in my commercial cases. I mean, although I'm sure half the sides think that. And yes, more feedback. The World Cup team captains all sent a letter to everyone complaining about we need to overturn our result. The president of Peru got involved, etc. Then Michael writes me, and anybody that knows Michael knows he types with 2 thumbs, maybe even a pinky. I don't know, but he's not a technologically savvy guy. He says, "Did you see my Wikipedia page?" I'm like, Michael, do you even know what Wikipedia is? Jesus. He said, yes, this is what it said until this case, okay? Member of Blackstone, practices in a bunch of areas. They added this. He's one of the 3 men who ruined Paulo Guerrero's football career. Community editing at its finest. Legal commentary, seldom has the law been as big an ass as in the case of Peru center forward Paulo Guerrero. I still give Mr. Ragozzi grief about that because he appears in front of me, but he said it wasn't personal. This was a case I promised to talk about because you got me instead of another speaker, and he was involved in this case. This is the case of the inflatable banana racism. So this is a UEFA match between FC Feyenoord and AS Roma, and a guy named Gervinho, who was an African player, had a banana thrown in his an inflatable banana thrown in his direction. And the match was pretty much out of control. I mean, just look at the arm movements they're making. I mean, Feyenoord had been sanctioned about 6 months before this for saying something objectively offensive to any human being about Islam. And they just didn't even fight it. They just they're like, yeah, we're screwed. We can't get around that one. So they took it. And this one was about whether the banana was a racist act directed at an African player. The match was wild and crazy, according to the footage. It was kind of out of control. The referee on the microphone, there's audio of all this. They have audio going all the time, and they record it. And the audio was like unbelievable. The dude was so stressed about keeping control of the match. Anyway, we ended up finding that this was a racist act, and under the UEFA standards, put out sort of a new standard under that case, and we gave them a penalty that dared them to do it again, because it would like double. If it happened again, it would get really bad for them. So that was kind of fun. This is a testament to the value of trial exhibits. So those of you that do a hearing, demonstrative exhibits are often the thing that's most remembered. In this case, there was a pitched battle at the end about that. The guy holding the banana is the guy that was supposed to be here instead of me. He was the chair of that panel, Alex McLean. He's the head of the Swiss Arbitration Association in Geneva, and he's American as well, oddly enough. But he, at the end of the hearing, everybody wanted to take home the damn banana. So the Feyenoord is like, no, this is our banana. It was part of our case in chief. And then UEFA's like, no, it's our banana. It was submitted to us in the file on appeal. During the hearing, they were showing us, this is the kid that threw the banana. He couldn't possibly throw the banana that far. Like, we had demonstrative, like, he's like throwing the banana so it goes like 3 feet. Couldn't go onto the pitch. Other people are throwing the banana. The arbitrators may have thrown the banana in one of the breaks. I will not confirm or deny that. But anyway, the banana ended up being the big exhibit, and this is now in the CAS repository somewhere. I've heard it has a hole in it. I don't know how it got that hole in it, probably from overuse. But this is a funny case. This was the case of the 62 Russian track and field athletes before Rio that were excluded from the games. I was on this panel. You can see me over here in the background there. The chair is standing, and I'm sitting there. This is one of Putin's alleged girlfriends, who at the time was the reigning pole vault champion in the Olympic Games. I can't remember her name right now. It's the first time I ever had anybody do live social media inside a hearing. I changed all my scheduling orders now as a result. They all have an anti-social media, no live streaming the hearing, nothing, like zero. It never dawned on me that anybody would do this. I got 10,000 likes on this one, just to be clear. Or she did on her Instagram. Okay, Beijing 2022 Olympic Games, real quick, CAS ad hoc division. I call this living in the bubble or daily diarrhea reporting. Either way, I finally look at it both ways. 14 days before I went, I had to report to the Chinese government about various ailments I might have had, and included on the list, if you look carefully here, is did you have diarrhea, yes or no? Now, I don't know of anybody that was bold enough to say yes. We had all these jokes about what would happen, if we did this, and more importantly, if they found out we had committed perjury on our daily diarrhea report. But nobody dared to do it because we were already in a bubble and we couldn't imagine it tougher. This is what it was like to arrive at the airport. I've never arrived at an airport where hazmat suits greet me right off the plane. This was the checking in to get your accreditation off the plane. They're all hazmated up. There was hazmat everywhere. This is what it was like to eat in the hotel. They had dividers at the tables. Imagine if that would have come in here. The British public, there would have been riots, but we could only sit in these like little cubicles to eat. That lasted for about a week and a half, and then lunch started, or then dinner and drinks started to lose it, and then lunch started to lose it, and by breakfast time it was gone by the time we left, but it was still kind of weird. This is an illegal photo. They actually took off their face shields to take a photo with me, and this is not their official photo they used. This was our friend photo. This is the doctors at the games that had to go see them for something for. And then they quickly put their face shields back on and took a proper photo like that they could use with their reporting officials. There was a question around this time, where is Peng Shuai? Remember her, the tennis player? I couldn't believe it. Day one, there's Peng Shuai. She sat down right in front of me. I got up and moved, and I was like, I got to take a photo from the side. So I'm over here like... there was Peng Shuai. She was easy to find, I think, for important public and political reasons. This is apparently what I did. I killed the Olympic Games, if you believe this article about my award in the Valyeva decision. The day the Olympics died. It's what it is. The decision's what it is. It was not based on the merits of doping. So don't believe the sort of self-righteous journalistic crew that exists heavily here. But actually, if you want to read it, you'll understand it's about procedural fairness. And that was really what was at stake. So there we go. Real quick tour through my reflections as a CAS arbitrator. I hope it was entertaining, at least to you as much as it was to give. So thank you.
Well, now comes the fun part. we're going to open it up for questions. You can ask anything to anybody. Just let us know, and we're going to let you go. And then also, because I promised a couple members of the panel, they can raise their hands and ask questions of their fellow panelists. So with that, does anybody have any questions? No one has any? Oh, there we go. I knew we had some people.
I'll ask you a question. A question, I think, in the first instance, probably for you, John. And I should say, by way of full and frank disclosure, that I am a Newcastle fan. Has there ever been a successful challenge? Oh, sorry. I'll start again. Sorry. Yes. So, the question for John, in the first instance, I've already mentioned that I'm a Newcastle fan. Has there ever been a successful challenge to a sports arbitrator? And if not, do you think there ever could be?
Good question. The answer is yes, and we'll give you a really good example in the CAS for the SFT, and that was the Sun Yang swimmer decision. You probably remember that one of the points he took on appeal before the Swiss Federal Tribunal was that the president, Franco Frattini, the Italian judge, a former minister, had sent out follow on from the social media points that Udo and Jeff mentioned. He had sent historic tweets about Chinese practices in relation to jobs and used disparaging references to that practice. Of course, he was considering an iconic Chinese swimmer.
Well, they were racist.
It's toward Chinese people.
Not just dog killing.
Well,
It was.
there's no doubt about that. and then, in addition, it was one of these, Jeff, I know that you had said that their decision to take a public hearing was a massive mistake, because this is one of the legacies of the Pepstein decision, that where an athlete is facing disciplinary sanction out of fairness, they're entitled now to a fair hearing, and the CAS have amended their rules. I have to say I found it very difficult to get a hearing in person during lockdown, but that's another matter. During that particular hearing, the CAS hearings are recorded, and this went out live, there were certain comments that he made that were audible about evidence given on behalf of Sun Yang in addition. And it's meant to be about his mother. And unusually, Jeff will know the statistics better than me, there's less than 10% of cases that succeed before the SFT, because it generally procedural. Yeah, it is very rare. But that was one that was remitted back because of alleged breach of objectivity and independence by Franco Frattini, the president. So that's CAS. Domestically, it is difficult to answer. And the reason why I say that, because I know from experience, I have challenged arbitrators, and I know that others have challenged arbitrators. But how it works in constantly the various jurisdictions that I mentioned here is that those are private decisions which are then taken. There typically is a retired judge who will determine whether a particular arbitrator lacks impartiality for the purposes of the Arbitration Act. I have tried, I think we may be on the matter together, we raised, and not names, the fact that this particular arbitrator had published on his website a leading case that he was involved in, whilst instructed for the other side's lawyers. This was kind of his marketing pitch, and he had not declared that at all, but said he was fully independent. We challenged that by saying you should have declared it, and secondly, you are promoting a case where you were openly instructed by the other side. That was rejected on the basis of what I said, that he is subject to ethical considerations. He has not been instructed recently by this particular firm, only about 2 years previously, but that was unsuccessful. So it is very difficult to succeed. I know anecdotally there are particular arbitrators that we all know who tend to be in favour of the institutions that they might be appointed by. And I know that challenges have been brought purely by way of correspondence saying that we will take this off to the High Court and raise your name, get you involved, unless you step down. I know anecdotally that rarely happens, but it has happened that a particular arbitrator or a did step down in those circumstances. So to answer your question, I don't know of any common law decision, I do know of SFT decision, but anecdotally
challenges do quite regularly happen, and in certain cases they have slightly taxing reasons.
I can tell you the law is
different in the United States, particularly in California.
All this Halliburton's
It's its case to me as a California arbitrator.
It barely
Sets any kind of a bar for DQing somebody based on attacks on impartiality and independence.
In California, my
Jams form I fill out for every case. And now I invariably screw it up. I'm not touching the right dots at the right time on DocuSign. It's like 12 pages long. There has to be questions about my family, about me, about
the lawyers
in the case, about witnesses in the case, whatever's been disclosed.
I have to report
on all cases that I've had with any of the firms before,
so that everybody knows.
because ultimately this protects the award.
I mean, the idea for the class
Is that for the rest of the room, you don't do this much.
once you disclose, the party that might have a challenge has
It's a very fixed period of time, usually
anywhere from 7 to 21 days,
depending on the institution.
in which to challenge.
And
challenging somebody's not a fun thing. It's a brave thing to do because
you're now,
you're going after the king.
I use this analogy all the time, but throughout history, if you
go to kill the king, and
And
you
you-
only injure the king in history comes back and kills
kills
you.
you, right?
So you got to be careful about how you
Raise these challenges with somebody that might still end up on the panel.
I think also in
This area, and I've been
pushing CAS to try to adopt the practice
of
Stockholm
and the
LCIA,
where they
started publishing excerpts of
or complete versions of their disqualification decisions.
because you need to
Educate the arbitrators in sports who aren't familiar with this.
about what they need to disclose, how they need to
disclose it,
what the conduct
is it's acceptable or unacceptable in the space.
And
Unfortunately, you have just this
honestly paltry
Halliburton guidance in this country that doesn't
offer it, whereas we've got tons of the stuff in the U.S. I don't even know what ethical
legal
code
would apply to me serving as an arbitrator.
I'm a barrister, but how does
The BSB handbook apply to me serving as an arbitrator? I mean, I can't lie, okay?
But I mean, it doesn't offer
Any
any
real
guidance
guidance
on
on
what
what
you
you
have
have
to
to disclose as a
arbitrate.
It's
That's an interesting debate.
In the area of
Form of ethical standards according to decisions.
In the area of stay tuned to this place, I will mention that tomorrow afternoon we have a presentation by Renato Grione on Halliburton v. Chubb. So just to let everybody know. Are there any more questions? I think I saw one over there.
I had a question I was going to ask Paul. Maybe it's for Jeff. I don't know. The CAS decision to reduce the Russia ban to 2 years, notwithstanding having helped up the WADA findings. What was the basis for that reduction to 2 years?
Yeah.
Consideration of fairness to the individual athletes. Design proportionality. Proportionality is a fairly subjective concept, to say the least. That was the decision. As I made clear in my talk, the introduction to the findings was an acceptance of all the terrible things as found, but then that half sanction. Anyone else wants to?
I purposely stopped talking
about those cases after 3 months because it just was going. It's hard to say. I was on the case, and I can't say much about it, but I just think the whole thing's a disaster overall. It was a method in its inception, and even the outcome's not great. The Rodchenko Act in the United States,
Travis Tiger
Hales is this great criminal statute. All it's going to do is shut down investigations. If you're subject to a criminal statute, you're not going to talk to anyone. You're not going to cooperate with anyone in this nice, friendly little anti-doping proceeding. You'll take your hit rather than take your jail term. And
to me, it's backward.
And I've told Travis that it's
the whole sordid thing
is a mess.
Should we be having the Russian, the Russian Olympic, it's not competing for Russia, but for competing for the Russian Olympic Committee, in your opinion?
As far as I have any say in it, I favour the idea of individuals being able to compete wherever they come from. But under strict conditions, if they come from a heritage which has been shown to be so corrupt, then there has to be some criteria imposed whereby they prove their claim to compete. I have no difficulty with that. I don't see why the individuals should be punished. But there is a very difficult situation where they come from a wholly corrupt system.
But under what flag should they be competing?
Independent, no flag. I think there has to be, if you're you're going to have an effective sanction on state-led doping, I think there has to be a national element to the sanction, and that's no better served than having the flag extended.
Can I go back to the 2016 decision pre-Rio? Because what that was a political push by the IOC. They delegated the decision back to international federations about whether they would ban athletes. And we all know certain heads of the international federation, national governing bodies. The reality is that other than World Athletics, none of the others really had sufficient funds to then pay for the inevitable challenge that was then going to come from any decision by any of those particular IFs or NGBs to the CAS. And you will probably recall it was athletics we banned, and the others did not. And that was just the start. And what was decided by a good friend of ours, Jonathan Taylor, Burn, in terms of the WADA position, was issuing a yellow card so that he felt confident that Russia would not then comply. And then a red card could be issued, which would tie the hands of any tribunal, because essentially yet another chance of being given. And so then to end up in a position that goes back to CAS pre-Beijing, only to find that the ban is reduced, just made a mockery of the previous 4 years, to be frank about it. But we can have another discussion about how close the IOC is with CAS and others. But that's another matter.
We have one more question. There. Oops. Oh, you've got it. All right.
My question kind of touches on understanding both impartiality and proportionality, because it makes so much sense from a proportionality standpoint, I guess, about the legal questions. But this is a question directed towards Mr. Udo. As a former athlete, looking in as an arbitrator, mediator, counsel, does that play into when you're thinking about the effect on athletes when 60% of them responded negatively, even if that was so long ago, thinking about their mental health? I don't know if that is something you have to disclose or how that factors in to your decisions.
Thank you very much. I mean, it's a very good point. Whenever I sit on these panels, like anybody else in the room, you're bringing your own personal experiences to bear. So I will look at it as an athlete. I will try to understand, as a former athlete, I will try to understand what pressures that athlete was going through that was making for her delving into these sorts of practices, what the competitive pressures are, but you're constantly having to balance all of that against making sure that the ethics of sport is kept up. Because what I always say, particularly with football, which is my sweet spot, which is what I love more than anything else, the beauty about football, if we were to compare it to, say, for example, a sport like athletics, the beauty about football, why it's such a popular sport, is that everybody believes what they're seeing. As soon as you have any sort of element of doubt that there is some fabrication going on, you're going to lose audiences. And that is what drives a lot of these sports organisations to be so strict and so hard on any athletes that are taking any sort of performance-enhancing drugs. So to get to your proportionality point, I do look at what athletes are going under and their competitive pressures, but my overriding wish and my overriding driver would be to make sure that things are kept and the ethics of sport are kept up. That's always my number one driver.
Not on drugs, but I sat on the Football Association against an appeal, and I can assure you I'm not an ex-athlete. There were 5 footballers in front of us on a betting scam, and they had bet on their own matches, their own team, 2 different teams. It's not a very wise thing to do, because the network is such you would not believe the CCTV footage that was available in your business. It was all pulled the case. And one of the players said, well, why am I here? I only had a £5 accumulator. And the match was only one of the 8 games in my accumulator. To which the retort was, yes, but you were the captain of one of the teams. Versus on the other side of things, someone filmed in a betting shop, going like this, £5,000 on the game. Oh, why am I here? Before the game, the manager sat me down and said, it's the end of the season, you're not part of my plans. What am I doing here? An indication of, without giving that as a background, how these factors come into play and what assessment we make of them. And you can imagine in that case, we didn't think very much of the arguments that came forward.
All right.
Sorry,
okay.
A very, very small point. Just to touch on your talk about the proportionality. In my talk, I gave a brief description of participants, and I said it's a very broad category for the FA regulations. It includes players, coaches, managers, agents. There is regulations that say there is no betting allowed whatsoever by any participant. So that's how wide range it is, and that's the sort of lengths that an organisation like the FA will go to keep the sport clean and ethically right. Nobody can bet at all whether you're a manager, whether you're a player, whether you're an agent, whether you're a kit man, whether you work at the club. You are not allowed to bet on any kind of football whatsoever. If it comes to light, and they have all kinds of software now that can disclose betting practices, the charge practices that I'm doing, I'm sure there's sat on many of these cases where people have been banned, who in their own minds believe that they were just having this very small bet on some game in the Scottish First Division. Doesn't matter.
All right, I'm cutting it off. At this point, I'm the ref. I'm blowing it full time. Because right now we've gone way over and we've got a drinks reception up there and we've had a wonderful discussion. They will be around. You can ask them questions. But at this point, I think about Paul's earlier statement about the very first doping involved brandy and strychnine. Well, we've got some doping in terms of wine and alcohol up there waiting for you all. And then why don't we continue discussion up there? But before we do, want to make sure we all appreciate these 5 speakers for what they've done. It's been a wonderful, wonderful time. Thank you.